Good morning, Judge Nkutha-Nkontwana.
Good morning, Chief Justice.
How are you this morning?
I'm reasonably good.
You are very good.
I'm good.
You are good?
Yes.
Okay, all right. I'm happy to see that you don't look nervous at all.
Well, maybe I can hide it better.
Thank you very much for availing yourself for consideration for appointment to one of the positions in the Labor Appeal Court. We appreciate your availing yourself. I'm going to ask you some questions, and commissioners will also ask you questions. The purpose of our questions is just to establish whether or how you fare when we compare your track record and your abilities with the selection criteria that we have adopted for the selection of judges. And we may be robust with you as we ask you questions, but nobody intends to demean you or disrespect you. You hold 2 degrees, is that correct? B. Juris and LLB?
Yes, Chief Justice.
You'll have to speak up because every one of the members of the commission here is very interested in the answers you give.
Yes.
Do you hold 2 degrees, B. Juris and LLB?
Yes, Chief Justice.
And you got your B. Juris at the University of Zululand?
Yes.
And LLB, did you get it at Wits?
No, I said it's the same institution.
Same at the University of Zululand?
Yes.
In 94?
Yes.
Okay, and then you got a certificate in industrial relations. Where did you get that from?
From Wits Business School.
Sorry?
From Wits Business School.
Wits Business School. Okay. And in 1996, you started working as a full-time commissioner at the CCMA.
Correct, Chief Justice.
Prior to that, you had not done articles or pupillage, is that correct?
Yes, it was fresh from school.
You had not done that?
Yes, I had not done that.
Yes, and that was 1996 to 2000. From 2000 to 2003, you were a labor consultant and part-time commissioner at the CCMA. You were a part-time commissioner at the CCMA?
So I commenced as a full-time I commenced as a full-time in 1996. I left in 2000. Then I became a part-time commissioner. And then whilst I was a part-time commissioner, I was then consulting.
You were also a labor consultant?
Yes.
Yes. And you were admitted as an advocate in 2003?
Yes, I was admitted in 2003.
Yes, and did you then practice up to 2017?
I practiced in 2017 when I was appointed as the judge of the labor court.
Okay. Did you do pupillage before you
Yes, I did.
got admitted?
Yes, I did pupillage.
Okay, in Joburg?
In Johannesburg.
Yes. Okay. Your practice as an advocate, how diversified was your practice in terms of branches of law?
My practice was predominantly labor. However, I did get a lot of briefs, or not a lot, maybe, briefs in constitutional litigation. I did environmental law. I think those are 2 that I can recall now that were significant, I think, in terms of my exposure, because I've appeared at the Concord led, and I also appeared on my own. So I did get a variety, but predominantly it was labor.
Yes. How much exposure have you had since you left varsity to law, other branches of law other than labor law?
As I said, I did branches of law, constitutional litigation. I did environmental law and other commercial matters, and litigating in different courts. I remember most of the cases that I did also were in Northwest, in the High Court in Mabatu.
Did you appear in some constitutional matters in the High Court or in any other court? Did you actually appear?
Yes, I did. I did one matter, I think most people soon before I was appointed. It was a constitutional matter, but it was done within the context of a trial within trial in a criminal case. And so they were challenging constitutionality of the Criminal Procedure Act. And then I was obviously representing the minister because they were challenging the constitutionality of those provisions. However, yes, we did file papers. I was led by SC in that matter. And the finality of that matter, then I got appointed. So I did. So there were others also in the High Court where the constitutionality of the provision was challenged, and then I was briefed to represent the minister.
But did you actually get to argue them in the High Court, or not really?
Not really in the High Court, but the only one that I moved was in the Con Court.
Yeah.
Yes.
Which one is that?
It was a criminal, obviously there was an issue about the then recently promulgated amendment to, a criminal, the definition, I think, of rape. And so I was there once more representing the minister, because it had created, the interpretation had created a gap in terms of the transition between the old legislation, because it was common law, then it got codified, then there was a gap. So I represented the minister dealing with that case.
Is that the matter where the judgment was written by Justice Nkabinde?
I'm not sure what it was Justice Nkabinde, it could have been. I'm not sure whether it was Justice Nkabinde or it was Jafta. I'm not sure, Chief Justice. I haven't checked that case.
Was it one judgment or?
It was one judgment, yes, it was one judgment.
Or was it the only matter in which you appeared in the Constitutional Court?
Alone, yes, not led. But led also appeared in the Merafong matters. The two Merafong, I did appear, but I was led by SC.
Yeah, I wouldn't forget who wrote the judgment in the matter where I appeared alone in the Constitutional Court.
I didn't think it.
Yes, okay, all right. So you got appointed to the Labor Court as a judge in, is it 2017?
Yes.
Yes. And you are still a judge in the Labor Court?
I'm still a judge in the Labor Court, but I'm currently acting at the High Court. I started this term.
You started this year?
This term.
This term?
Yes, the commencement of this term, which was on Monday.
Yes. And I guess it's too early to ask you how you are finding it, is it?
No, yes, I have been finding
yes. Now, if you are appointed to the Labor Appeal Court, you will be sitting in a court which is required to give this country labor law jurisprudence and develop labor law for the country. The Constitutional Court will step in from time to time, but largely the Labor Court and the Labor Appeal Court are supposed to drive that process. Therefore, you need to be alive to issues and debates around a number of issues in the labor law field. Do you agree with that?
I agree, Chief Justice.
Yes. What can you share with the commissioners in terms of what you are aware of in terms of different schools of thought about jurisdiction between the labor court and the high court in regard to certain matters that have got either labor or have got labor elements? That's a debate that has been going on for more than 30 years, even before the labor court was created under the old regime. That debate was there. What can you share with, what are the issues, what are the debates? Those who take one view, what do they say in support of their school of thought? Those who say something else, what do they say in support of their school of thought?
The labor court is a specialist court, and it finds its jurisdiction in the Labor Relations Act, and it also gives it exclusive jurisdiction in respect to labor matters. And however, the LRA does give the labor court concurrent jurisdiction on constitutional matters that emanate from employment law or labor relations. And then you also have, so you have to then discuss the jurisdiction, because once you say concurrent, it means there's another court that has jurisdiction. I think that's where the debate starts. But also I'm aware also that most of the matters I think that serve in our court is when it relates to the contractual matters. And then the court would exercise its concurrent jurisdiction in terms of basic conditions of employment, Section 77(3), on contractual matters that emanate from employment contract, let me say that. So the tension is, as it was discussed in, I think, the power coming from Chirwa to Gaba. I think when you look at the SCA in Makanya, then the jurisdiction was properly explained. I think those judgments from the Constitutional Court, that the jurisdiction, it talks about power of a court to deal with the matter, and if then that power derives from the legislation, and that legislation defines clearly the court that has to deal with, then the High Court cannot deal with those matters. However, you do get matters that a litigant has two claims that emanating from similar facts, of same facts. So in those instances, then the litigant can forum shop. So the litigant can decide, well, I want to vindicate my right in terms of the Labor Relations Act, then obviously to go to the labor court. But if he says, I want to vindicate my rights in terms of contract and common law, then he can still go to the High Court or come to our court. Then we will sit as a High Court, because obviously we're exercising our concurrent jurisdiction. So the tension, I think, is because, as Makanya explains, that there is confusion that, you know, sometimes the High Court will shy from exercising its jurisdiction, which is common law because it's contractual, or in some instances it could be jurisdiction that emanates from the Constitution, and because it would come from the employment field, yet they could deal with it because the labor court is exercising a concurrent jurisdiction. And obviously from the labor court's perspective is also when the labor court cannot exercise a jurisdiction because we think we don't have that jurisdiction. So the debate comes from that, but it is clear that a litigant is not barred from forum shop to an extent that that court has jurisdiction to deal with a particular dispute. So to an extent that I think in Makanya, that dispute had been through the labor relations processes, and however, the litigant chose to vindicate his rights in terms of the contract. And I think that's where the tension was. So I'm saying if a cause of action emanates from, it's one cause of action, and a party must go to a specialist court, to a labor court, then the High Court would not have jurisdiction.
You talk about the concurrent jurisdiction between the High Court and the Labor Court as provided for in Section 77 of the Basic Conditions of Employment Act. Does that act not place a cap of a certain amount which must be determined, I think, by the Minister of Labor, to say those employees who earn above a certain amount, they may not avail the Basic Conditions of Employment Act in relation to their matters? Is there something that says that, or am I mistaken?
Chief Justice, I'm not sure, because 77.3 in capital A, it says it matters that it's contractual matters, even if it's not a term of contract. So, which means then it gives a scope that is wider. So then the issue of threshold would not apply. However, threshold would apply when you are now dealing with the terms that emanates from the Act itself. Mm-hmm. But 73 says even if it's not a term of a contract, and I think we've dealt with a lot of those issues when a litigant would come to our court challenging unlawfulness of the dismissal. I think there's a new trend that is emanating, that because of Steenkamp, litigants are now aware, the Constitutional Court judgment, that in the Labor Relations Act, there is no unlawful dismissal, for example, or unlawful suspension. So they will then come via the Section 77.3 and then says it is part of their contract that they are vindicating the rights in terms of their contract, which most of the time is read with the policies.
Mm. And are you familiar with what a sympathy strike is?
Yes, I am familiar with what is a sympathy strike.
What's the difference between a sympathy strike and a secondary strike?
A sympathy strike is when the strikers are striking in support. They're sympathizing, but it's not because the issues that are demanded impacts upon them. And then a secondary strike, it's a strike that I think is linked to the issues, to the demands.
Mm-hmm. And are you familiar with the grasshopper strike?
Grasshopper.
Mm-hmm.
Trying to think. No, I know remember the definition of strike in Section 20. It's wide. Grasshopper strike. If you can refresh.
Oh, okay. No, it's fine if you are not familiar with it. Are you familiar with the debate about the applicability of the Prescription Act to labor disputes such as unfair dismissals? And if you are, would you mind sharing with the Commission what you understand the different schools of thought to be?
Yes. I think when those debates, I think, were traversed at the Constitutional Court, and Manyataza, I think, comes to mind as I'm sitting here. And I think the debate was would the Prescription Act apply in labor matters? I think that was the debate. And it was resolved later on in, is it Khawulishwi, or, but it's that like the Concord case, where it said, because of the Labor Relations Act that provides condonation, it does apply firstly, let me say that, and then a party still who is late in referring a matter to the CCMA can apply for condonation, and then once a dispute is referred, it interrupts the prescription. So up until its conclusion, if there is a review and there's appeal, then the prescription is interrupted. But as soon as the litigation process is concluded, and let's say litigant doesn't vindicate its rights in terms of that award or judgment, and then so after that judgment, the finality of the process, then the prescription will commence. So an example would be, if there was an award, there was an award that was rendered, I think that the two debates. So you'll then start saying, why didn't you vindicate your rights within the prescription period, which is 3 years? So, and then you would also, another debate would be then it was an award, a judgment, and if it's made an order of court, then obviously the period of prescription would apply, because we know if it is an order of court, then it's 30 years. If it's and it's just a debt that is vindicated, it's 3 years. So in a nutshell, that is the debate.
Okay, if you are appointed to the Labor Appeal Court, you will be sitting in an appeal court dealing with appeals against judgments of the labor court. Are you familiar with the two types of discretion in law that you might have to deal with in appeals that come before you, where judges of the labor court will have exercised some discretion in making their decisions?
Yes, Chief Justice, there are two types of discretion. It's a wide and narrow discretion.
Yes.
And a wide discretion is a discretion that, when exercised, an appellate court cannot interfere with. And an example, it would be, I think in our court, condonation, it would be granting of condonation, it would be postponements. So it's the court, if it wants to interfere with that exercise of discretion, it has to test whether it was judicially exercised. You look at whether there was proper understanding of the law applicable and other factors. When it comes, that is the strict or narrow discretion. When it comes to the loose or wide discretion, it's when then the court, seized with the matter, can also traverse the merits and deal and exercise that discretion, and it doesn't have to look at whether it was judiciously exercised. And I seem to recall there's one case of, I think it's Dr. Kemp, it was an LAC case, and I think Chief Justice said in that case, where it had to deal with compensation, and I think that would be an example where then an appellate court can exercise that discretion and deal with an issue of compensation that emanated from the Labor Relations Act, which is Section 193.
So what's the difference between the two types?
The difference between the two is that the other one, obviously, the appellate court is constrained to intervene because it's a strict and a narrow. If it does, then it must satisfy itself that a discretion was not exercised judicially, or it was exercised capriciously or arbitrarily, or that there are a lot of points. And then with the other side, you don't even have to look at those points, whether it was judiciously exercised. The court that is seized with the matter at the appellate level, it can interfere with that, and then also traverse the facts and exercise that discretion.
Thank you. I'll now give the Judge President of the Labor Appeal Court and Labor Court the opportunity to put questions to you.
Thank you, Chief Justice. Good afternoon.
Good afternoon, JP.
It's nice. I've missed you this term. Are you enjoying it at the
No,
High Court?
I cannot say for now because of these interviews. So I hope once I'm done, and I'll be able to focus there.
All right. I'm looking at the feedback we received from the law bodies. I noticed that you have the support of BLA and the GBC, but not the LSSA, which is the Law Society of South Africa. I looked at the reasons and it just mystifies me. It appears in 6 years you have 3 of your judgments overturned. And they say, my Lord, that's too much. So you should be given some more opportunity. I don't think you need to answer that. All right.
JP, please speak up a bit so we can hear you.
Oh, sorry. Do I need to repeat that?
Please repeat it for me.
Okay. I was just saying that look at the feedback we received from the law bodies, and I noticed that you were supported by the BLA,
Yes.
by the General Bar Council, but not the LSSA, the Law Society of South Africa. And they base it on the number of matters appealed where your judgments were overturned on appeal. And they've come to 3 judgments in 6 years. And on that basis, they do not support you. I find that extraordinary. I don't need you to comment on that. But I do know one of the judgments was on restraint of trade, where you weren't reversed on the decision of the restraint of trade itself. It was only the one part of it, and that was the period of time.
Yes.
I think you upheld the 3-year restraint, and the LAC said 3 years was a bit long, and they reduced it.
Yes.
Is that correct?
Yes, that's correct.
Yeah. I'm just mystified, as I said, why they do not support you based on the 3 judgments which were upset. And then there is an objection from JOSA and Aweshi attorneys,
Yes.
which is an attorney and his client,
Yes.
and they've raised an objection that you refuse to hear them. What I find also surprising is that all attorneys know that if there's a problem with that, come to court and you refuse to hear, you go quickly to the JP or you go to the DJP. One of us is always there, you know, and to lodge the complaint. They never did anything. The registrar gave them a date a week later, which they were happy with. And you did hear the matter, isn't that?
No, if I can just put context, I think I did send some note to the commission about that. I never refused to hear the matter, JP. I said the matter was given to me at 2 to be heard at 2:30 in the afternoon. I said to the registrar, I don't mind hearing the matter. The matter must be heard the next day. The next day, the matter was not heard. I was told by the registrar that the matter was set down for the following week, and that's how it ended.
Sorry, you're absolutely right, yeah. It was the registrar who negotiated and gave them a date next week.
Yes,
You had
but I was
nothing
willing
do-
to hear it the next day.
And is it correct that judges actually don't allocate matters?
No, I don't allocate.
Only the registrar does?
Yes.
Thank you. Then the next complaint was Kunene versus the right to care.
Yes.
I think it was a sexual harassment matter
Yes.
where a claim of 3.5 million was sought against the employer for not taking action quick enough.
Yes.
And he found for the employer,
Yes.
and he refused leave to appeal. And I can tell you that the LAC was petitioned, the LAC was petitioned, and they upheld and they refused to grant the petition. So you've been upheld on that.
Yes, but my view on that also was that I think when parties have availed themselves to appeal, it is not for the judge who assists with the matter to comment on the merits. So, yeah, that was my take. And however, I think in those matters, you look at the body of evidence that is before you when you decide.
Thank you, you're right. Now, you've altogether got 14 years experience in labor law, 6 as a judge and 14 in practice. That's 20 years. Sorry.
20.
Yes. And from your judgments and practice, I see you're quite comfortable in doing what you are doing. Is that correct?
Yes, I am comfortable, and I think when I read the script of my last interview, one promise I made was that when I'm appointed as a full-time judge, I'll be able to render my judgment expeditiously, and I think I kept my promise.
You have kept your promise. I have no reason to ever talk to you about reserve judgments.
Yeah.
Thank you so much for that. And I'm not going to ask you about your knowledge and expertise. I think the Chief Justice has done that. That is all, Chief Justice. Thank you very much.
Thank you. Minister? You're covered. Thank you. Commissioner Marumohai?
Thank you very much, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
I just want to ask you a more substantive question. I see that one of your judgments, you had an opportunity to write on the intersection between company law, insolvency law, and labor law, business rescue and retrenchments. And I read the judgment. I have no great difficulties with the judgment because I think the approach is right. But like you are saying in the judgment, there have been conflicting decisions in respect of, one, the jurisdiction of the labor court in dealing with those matters. But most importantly, whether one of the affected parties, which is the employees, under those circumstances can actually approach the court on an urgent basis to get the relief that they are looking for when they are faced with retrenchment from a business rescue practitioner, where the moratorium provision is clearly stating that you cannot do that without the consent of the practitioner or leave of the court. What I want to get from you is, when one has regard to labor rights generally, and the right to employment in particular, if there is such, under that understanding of that this is a constitutional right, what is your view in respect of saying perhaps there is a justification for employees to be able to bring these applications, notwithstanding not meeting the required sort of threshold in the provision? In other words, by not having had first obtained consent or even the leave of the court. In other words, as a way of right, what would be your view with respect to that?
Remember that emanates from Companies Act. And the Companies Act, I think I mentioned in that judgment that it created that system of business rescue, that scheme, and that scheme obviously resides within the High Court. But if an employee has an urgent need, as you've just articulated, they must go to the High Court on urgent basis, as long as they can prove urgency for the leave to challenge, to vindicate their rights. Then once they've got that leave to litigate, remember, when it comes to business rescue hopes to rescue a company, not to kill a company. And then the provision is to give the practitioners an opportunity, a breather, as they try to assist this company that is going down. So, but if there are rights that if they are delayed, then they're going to be negatively impacted, the Act has provided a system, a procedure, and that procedure takes you back to a judge of the High Court who can then grant leave, and then a person negatively affected can then vindicate their right.
Thank you very much, Judge. Thank you, CJ.
Thank you. Commissioner Singh.
Thank you very much, Chief Justice. Good day, Advocate. You were advocate when we interviewed you the last time when you applied for the Electoral Court and the Labour Court, and you decided to stick with the Labour Court and not the Electoral Court. Was that a wise decision in retrospect?
Yes, it was. I don't regret joining the Labour Court.
Thank you. Related to this, you list 2 reserve judgments.
Yes.
And then they were quite recent.
I've delivered those judgments.
You've delivered them. maybe for the JSC, I mean, we want to know what's best practice as well. To what do you owe this ability to write your judgments as quickly as you do? And what's the longest you've taken to write a judgment?
Well, I've always, obviously we've got 3 months, I think, in terms of practice to render our judgments. So I've tried to make sure that I keep to that. So I track my judgments and make sure that I do the oldest first so that at least I'm not lagging behind. But I must be honest, it takes a sacrifice. It takes a sacrifice because you have to, you know, your social life gets curtailed. And however, I'm enjoying it and I don't have qualms about it. I think it's a matter of, once you found a way of dealing with them, you can, but not discounting that there are also personal circumstances that can prevent a judge from dealing with the matters expeditiously. However, the standard and the practice is 3 months, and that's what we are expected to adhere to.
Thank you for making that sacrifice, because they say justice delayed is justice denied, and you are certainly not denying justice. Thank you very much, Chief Justice.
Thank you, Commissioner Singh. The last one on my list before I go and look at the commissioners on the platform is Commissioner Nkutha-Nkontwana.
The professor covered me. Thank you.
You're covered. Thank you very much. Commissioners on the virtual platform, I didn't see any hand. I'm told Commissioner Barnett. Commissioner Barnett.
Thank you, Chief Justice.
Go ahead.
My question, good day, Judge. My question is just on the solidarity with stays and the South African Police Services case.
Yes.
On page 23, the award, I'll just give it to you quickly, you don't really have to look. You award one amount in the capital, but you say that 3 respondents must pay that to the claimant. And then you also make a cost award against the 3 respondents. And the wording is done that the respondents are to pay the costs. So it creates a practical problem in practice with enforcement. And my question is just, do you not think it would have been better to follow the practice where you grant cost orders of that nature, and even in this case the capital, to the parties jointly and severally, the one paying, the other to be absolved? So it's just a practical question. If you can just comment on that, please.
I note your comment or your question, and I'll look at it. But in this particular instance, because it is government, remember that was litigated against. So most probably I didn't, expound on it because of that.
Thank you, Chief Justice.
Thank you very much. I've not been told of any indication from the commissioners on the virtual platform. I assume that was the only one. Commissioner Barnett was the only one. I will allow the JP. JP?
Thank you very much, CJ. Good afternoon, Judge Nkutha-Nkontwana. Or the other way around, sorry.
Nkutha-Nkontwana.
Okay. You mentioned that you are currently acting in the Gauteng division, and you are the second judge this year from the Labour Court who has come to act in the High Court. Could I ask what motivated you to want to come to the High Court?
I think it's exposure, and you want to be better exposed in terms of your career and growth.
Yes.
But also, I think you're at a stage where you want to decide where you want to, in terms of your career development, what would be your next steps. So I think High Court, it's for me to just get exposed.
Yeah. Well, I think it will it will come in very good stead for you. You'll have a very good taste of what appellate work involves, because as a labor court judge, you don't have appellate work, am I correct?
Yes, we don't have. Yes, we don't have.
Yeah. But the last question, CJ, that issue about you refusing to hear a matter, it worried me a bit that the parties came and they came in the urgent role and they wanted to be heard on that day, and you said, no, I'll hear them tomorrow. And by the time you were ready to hear the matter, as the saying goes, on that side of the table, there was already blood on the floor. And there would have been no value in you hearing the matter.
The horse had bolted.
The horse has bolted. What's your philosophy? I mean, you may have not been able to read the papers, but it's not the first time that an urgent matter rocks up in a judge's role that way, where there's demonstration of imminent harm. Now, I want to understand why you refused or you didn't hear the matter on that day.
I didn't say I refused to hear the matter. I don't allocate matters, the registrar. So there was not clear indication that was allocated. But another consideration was that the period, and I thought most probably then it would assist if they come back the next day, because they would have served those papers to the other party. But I must be honest, I didn't refuse to hear that matter. The confusion came from the office of the registrar.
Yeah.
So I cannot take it any further.
Hopefully, when you
I
go
understand.
back to the labor court, you will share the message that registrars are not that powerful in the High Court. They don't allocate work to judges. Thank you, CJ.
Chief Justice, can I just follow up on this
Thank you. Yes.
exchange?
Yeah.
Judge, the complaint seems to be a narrower one, which is that the disciplinary hearing was scheduled for 4:30 on the 30th of August. The application is brought before you on the same date at 2:30. And that's why they want the hearing. I mean, they had already lost. It sounds to me that they had no prospects anyway. And that if you had heard the matter, you would have dismissed it. But the problem that they are raising is that we've got a hearing at 4:30. We ask a judge to hear us at 2:30, and the judge says, no, I'm not coming to court. I'll see you tomorrow. That's fine if the disciplinary hearing can be postponed. But what they say is that at 5 o'clock, all of the 70 workers were fired. And they probably would have accepted the dismissal if their application before you had been dismissed or struck, whatever. But what seems to be making them very unhappy is that you just refuse to hear the case. So that's really the harm that is at stake, that maybe you should really explain. Did you know that the disciplinary hearing was at 4:30 that day when you said, I'll hear the case tomorrow at 10?
No, at that stage, I was not aware that there was a disciplinary hearing at 4:30. If I was going to hear the matter. But still, if they came back the next day and said the people were dismissed, and as a court, if they'd made a case, I think you have a discretion, you have a lot of remedies that you can avail to parties. So I don't think that I was not going to be able to deal with it the next day, and give them an order that was going to assist in that regard.
But I mean, how did you not know that the disciplinary hearing was at 4:30? Was it not in the founding papers or in the notice of motion?
As I explained, you see, what happened is the registrar comes and says, here are people who are coming at 4, at 2:30, they want to be heard, it's 2 o'clock. And then I said, okay, because my understanding is that the registrar didn't allocate that matter. So I said, can we hear this matter the next day? And the registrar then said the matter will be heard the next day. So I'm saying is it was not properly before me. That's what I'm trying to say at that particular stage. And I seem to recall the discussion that I had with the registrar that there was the 31st or what, that they were going to serve or what. But there was a history to it. I'm not sure why I couldn't pick it up. But I take your question and your concern.
No, I've got no concern. I'm just pointing their concern.
Yes, but I'm saying their concern, yes, and I tried to deal with it. I can't take it any further.
No, I
understand where you're coming from, and I think as JP Mlambo has just alluded to, so I understand.
No, the only thing I'm investigating is if you were aware that the matter is at 4:30, then you should hear the case, strike it, dismiss it, whatever, instead of just telling the registrar to go back. That's what I don't understand. I mean, I thought maybe you didn't know. But if you didn't know why, because the papers are there in front of you, that's the only thing I'm trying to get my head around, if you know what I mean. Yeah.
No, yes, I understand what you are saying, we are asking. But as I said, that case came before, the registrar approached me, and then the registrar said, there's the case. When the case is on the roll, you go to court, you do a case. When the case is not on the roll, the registrar must tell you why it's on the roll and why it must be enrolled. So in this particular instance, as I said, it would seem as if there was a confusion between myself and the registrar, because my understanding was that the litigants could be heard the next day. And I said the matter will be heard the next day. And I was amazed because I was willing to hear it the next day when they said the matter is set down, not for the next day, but for the following week. And then it baffled me then that. So that's all I can say at this stage.
Thank you, CJ.
CJ, may I do a follow-up
Yeah,
just to
sure.
hear something? Good afternoon, Judge.
Good afternoon.
Judge, just so that there is no confusion, when you made the decision that they can be heard the following morning, had you looked at the notice of motion? Because it's not clear from this engagement whether you had the notice of motion in front of you. And I think that's what Commissioner Nkutha-Nkontwana is trying to establish with you.
When the matter was brought to me, the registrar is having the file. It says, I have this matter. These people are coming here now. They want to be at 2:30. And I said to him, this matter, can it be heard the next day? You understand? So that is the way the discussion said. And the 31st is the next day because it was the 30th. And I said I can hear the matter the next day, which was the 31st.
So you didn't look at the notice of motion?
I hadn't looked at that matter, I must be honest.
Okay.
Because if I had picked it up that it was that urgent, I was going to hear. I've never refused to hear matters. And it would have been the first time that I refused to hear a matter when it was that urgent.
Thank you, Judge. Thank you, CJ.
Thank you. Were counsel or the lawyers already in the premises of the court when the registrar brought the file to you?
Yes, they were.
Well, shouldn't you have asked her or him or her to bring you the lawyer so you could ask them why is it so urgent that it couldn't be heard the following day?
I didn't ask for that, JP.
Because it's not the registrar's matter, and the registrar might not be a lawyer. The real people you should find out from are the lawyers representing the parties. Because if you had asked them, they would have told you that what we seek to interdict is going to happen in a few hours' time, so tomorrow will be too late.
Yes, JP, most of us should have, but at that particular time, it wasn't clear that what was happening. I must be honest, because I was with the registrar. Ordinarily, things don't happen like that. Most probably, I was not sure what is the process, because I get a role, I go to court, I'm told this matter is allocated, you go to court. So I think there was something that was not familiar.
Yeah, well, urgent applications come at all kinds of times. They come after hours. And so I think that you'd be well advised next time to say you want to see the lawyers so that you can hear from them the degree of urgency.
Yes.
Okay. I don't think that there is any.
For interest sakes, I'm sorry to come so late, but there was also something that was an objection from the Mate with
Yeah.
regards to the issue of the.
You want to put it to
I
her?
just wanted, maybe she can also explain that.
No, I don't think she has had you talk to her. You want her to explain something?
So I'm sorry, good afternoon, Justice.
Good afternoon, Commissioner.
So there was also the issue of one matter that put an objection of you because of the use of.
Please speak up a bit.
Because of the
Commissioner.
approval, thank you, ma'am. Because of the approval of the use of a lie detector, there's something, maybe you can
Yes.
explain to us
Yeah,
what
yeah.
is the issue there?
Yes, I can
And
explain.
it, maybe I must also, as an elderly, repeat to say that it seemed as if you were very impatient in the case of the workers. And sometimes it helped to be a little bit more considerate. Thank you.
We're talking about the use of lie detector. In that matter, the perpetrator had already been dismissed, but the investigation that was conducted leading to that, maybe the context is that it would seem as if the complaint came when there were issues of performance, and then the complaint was registered. But the employer asked the parties through the investigation, and then a lie detector, I think it came because it wasn't clear to the employer at that stage, I think. But as soon as it became clear that the result, the employer decided to follow a disciplinary route. The perpetrator was charged as soon as possible, and the victim participated through the process, and ultimately the perpetrator was dismissed, and the perpetrator challenged that decision, and it was unsuccessful. So here you're looking at the test in terms of Section 60 of the Employment Equity Act, when it says the complaint must be registered as soon as possible, and once the employer knows, and then what procedure they're going to take. So it would seem as if here the employer decided to take a disciplinary procedure, and then that is the context.
I'm really not clear, but I know you don't want us to ask a lot of questions.
Yes.
It's fine.
Thank you. We have reached the end of this interview. Thank you very much once again, Judge Nkutha-Nkontwana, for availing yourself. You are now excused.
Thank you.